And joining me now to break down today's decision is criminal defense attorney David Shapiro. David, we're picking up a conversation that you and I started actually at 5 o'clock. So let's start with this new evidence, the letter. The question is, if Gascon made this decision today, does that mean that he proved the legitimacy of the letter in terms of age of ink or handwriting? What does that mean in terms of what he found for that letter?
Well, what it means is that Gascon looked at it and found it to be credible, right? I think he even came out and has said that he believes, maybe not everyone in his office, but he believes that the boys were molested at the hands of their own father way back when. Now, that's just one factor in his decision today, but it's certainly something that could weigh on him very heavily. But what's to keep in mind is that he still said this was a murder, and this was a first-degree murder, despite making the recommendation that he did to hopefully make these brothers parole eligible.
You just mentioned it. He did acknowledge that there is a faction within the LADA's office that does not agree with that. They say the boys went out and bought the rifles, that they shot their mother point blank, that they went on a spending spree after they gunned down their parents. How does that play going forward as it hits the judge?
A strong argument in 2024, a stronger argument back in 1989, 91, 96, at the second trial in particular. What we know today about trauma, what we know about reactions to trauma may not be normal, may not be natural to people who haven't lived through it, but no people deal with trauma the same way. And what it comes down to is, or if there's two or more reasonable interpretations of this evidence, one points to guilt, one points to innocence or not guilt, they should be given the benefit of the doubt. And really that was their argument at the first trial and certainly at the second trial, although they were stripped of so much of that defense.
What has changed in the 30 years with cases involving defendants that are under 25 years old, where abuse may be an issue? What has changed?
Yeah, well, the law changed recently here in California where those things need to be considered. It's not just you can or you should. You must consider those factors. And what we have are individuals who are 18 and 21 years old, well under that 26-year-old threshold that we hear so frequently, that even though they were tried as adults, as anyone would be after their 18th birthday, the factors of their youth, the factors of their development, the factors that they have alleged to have been traumatized as kids and really had their childhood taken from them as kids, assuming that was true, all those things factored into, at least they should have, into Gascon's decision. All those things would factor into potentially a jury's decision if this case were to ever be tried again in 2024 or 2025.
And as you pointed out, Gascon still said this is a murder case. He could have recommended the manslaughter. Talk about really, as people are viewing his decision, kind of where he went, which is middle ground here.
Without question, he went middle ground, and it's a sign of a great compromise, right, where no one's really happy. The factions in his office that believe that this is all just an act, that these brothers have been acting about the abuse for 35 some odd years, they're not happy about this. They believe they should die in prison. And there's another faction of that office in Los Angeles that believes that they should be released ASAP on a manslaughter conviction for which they would have served that time well more than what the maximum they could have gotten under law. By coming in the middle here, he says either way the judge was going to make the ultimate call, but even if the judge now says, yes, I agree, it still goes to a parole board for consideration. So by coming in and saying, hey, this is still a first-degree murder, it is really right in the middle, and it's not the position that a lot of people thought he would take.
And you think we'll be talking about this for months to come? By the time it goes to the parole board, it would have to go to the governor after that?
Yeah, there are several steps here. The first is that hearing that's going to be set in about 30 days or so, assuming the judge signs off on that. Then it just means that the Menendez brothers are parole eligible under youthful offender parole here in California. They still need to get a hearing. There needs to be a hearing set, preparations for that hearing, and then even if a parole board says, yes, we agree, one or both of you are parole eligible and you should be granted parole, there's still a whole process that goes months, not weeks, not days, months deep into 2025.
All right, we hope you'll come back and keep speaking with us as we follow this case.
Absolutely.
Thank you, David Shapiro, defense attorney. We appreciate your time this afternoon. Stay with ABC 10 News for the latest developments in this case, and you can get updates on 10news.com or our mobile app.